Yilmaz, who will speak on advanced directives and do not resuscitate from a comparative perspective. Thank you.
Dear Chair, ladies and gentlemen, it's a pleasure for me to greet medical law experts from all over the world. All welcome. And it's a great honor to be able to address such a distinguished audience. Today I will talk about advanced directives at the end of life in different legal systems. As medical technology gets better and better, lives are extending, and this causes new challenges because as the life is extended, the context of dying changes. We have more and more terminal patients, we have more chronic illnesses, and we have to make decisions at the end of life. At the same time, we have to ensure the patient dignity and autonomy while all these are occurring. This becomes a legal and an ethical challenge. There are some core concepts at the end of life. By end of life, I mean the situations where disease progression or significant health deterioration irreversibly threatens an individual's life in a very near future. And end-of-life care is the care we provide to patients in end of life. This is usually palliative or terminal care. An end-of-life decision is a medical decision actually made by the treating physician, in consultation with the patient or their surrogate. The guiding principle here is the patient self-determination. We have to preserve patient's autonomy at all times, and all the decisions we make should be medically correct, and at the same time they should be done in consultation with the patients. And advanced directives are useful tools while doing this. What are advanced directives? Advanced directives are legal documents outlining an individual's preferences for medical decisions in the event of future incapacity. And the purpose is to protect and enact a patient's autonomy and previously expressed wishes when they are no longer able to make decisions for themselves. There are mainly two basic legal and ethical foundations. One is Oviedo Convention, Article 9, which requires that the previously expressed wishes of a patient should be taken into account. And we have the US Patient Self-Determination Act from 1990, which also regulates the right to accept or refuse treatment and the right to formulate advanced directives. Globally, the most common types are the living will and the healthcare power of attorney. What are these? The living will is a written statement detailing a person's desires regarding their medical treatment in circumstances in which they are no longer able to express informed consent. Usually, the living will includes specific interventions like DNR orders, CPR, perform CPR or do not perform CPR under certain conditions, or mechanical ventilation, or artificial feeding, or hydration. On the other hand, the durable power of attorney for healthcare, or healthcare proxy, is an instrument for appointing a surrogate to make healthcare decisions when one is no longer in state of deciding for himself. And actually, the agent is legally bound to act in accordance to patient's wishes, known wishes, or in the person's best interest. And now, lately, there is a modern approach which is getting more and more popular in the United States, the POST model. POST is the abbreviation for Physician Orders for Life-Sustaining Treatment. It's a more dynamic tool, and unlike a traditional directive, it's a portable medical order which is designed by the treating physician in consultation with the patient, taking the medical condition of the patient and the values and wishes of the patient into account all at the same time, which is a big advantage. There are some key distinctions from a living will. Living will is something the patient states, makes a statement before his health is in danger or in trouble. But this is a medical order defined and signed by a healthcare professional who is treating the patient, who knows the patient very well, who has an idea about the prognosis of the patient. So it's not a legal directive, it's more than a legal directive. And living will is prepared while the patient is healthy. The POST model is intended for individuals who are seriously ill or who has an advanced illness, whose death is expected in a very near future. And this is prepared by the treating physician in consultation with the patient regarding the patient's values and wishes. And once it's prepared, it's valid in all settings. It doesn't matter if the patient is at home or in a nursery home or in a hospital, it's overall valid. Of course, in the United States, the legal landscape is decentralized. The federal framework is formed by the Patient Self-Determination Act, and the specific advanced directives are valid all over the states. Actually, the living wills and durable power of attorney are valid in all the states and widely used, while POST is rising. The moment I made a research about this, 44 states were using it actively. It might be a little more.
2 minutes left.
Oh, I'm almost finished. Thank you, Mr. President. Now I think it might be some more. And when we have the European framework, of course, the Council of Europe is the standard key standard setter. The Oviedo Convention in 1997 is an important tool. In Article 5, we have the general rule of informed consent. Article 6, protection of persons not able to consent. And Article 9, obligation to consider previously expressed wishes. And in Europe, again, we have recommendation CN from 2009. It urges member states to promote legal mechanisms for advanced directives. And there is an important guide on decision making, which was published in 2014. And this guide provides a practical, non-binding guidance for clinicians, patients, and families, emphasizing shared decision making. together with the physician and the patient and the family and or the surrogates, and this has a patient-centered approach. And how about other countries? In Germany, the Civil Code explicitly recognizes the patient's will, making it legally binding for the appointed guardian and physicians. In Switzerland, the law is rooted in protection of strictly personal rights. The concept of a healthcare proxy is also legally established. In Austria, there is a specific Patients' Instructions Act, and this allows for a healthcare power of attorney. What about Turkey? Actually, our legal system is based on the Swiss model. Our constitution and patient rights regulation protect bodily integrity and the right to refuse treatment. However, we have no formal legal instruments arranging living will or other forms of advanced directives, which I think is something missing, and it has to be completed in a very short time. There are some challenges in implementation and practice. One could be underutilization. Many people fail to complete directives. Communication gaps can be a problem. What the patient says cannot be understood by the patient, what the patient says in a living will, for example. There might be some interpretation problems, so if it's prepared, it should be very carefully prepared and checked. And as to the post forms, there are 7 deadly signs in the literature defined. These are things which you shouldn't do. One is that a post form is used for somebody not ill enough. It should be used for people who will die, who are expected to die in the very near future, less than 1 year. It's a fault if it is prepared without shared decision making. It should be reviewed regularly. Documents should be reviewed depending on the changes in the patient's condition and wishes. Post form should never be prepared by the patient alone. Providing incentives to complete more post forms, it was done in some states in the States to make people get used to. I'm finishing. Yes, I'm finishing. In the States, they give some incentives, and then improper use of post forms were observed after that. They should be stored very well, and the use should be evaluated regularly. And actually, advanced directives are very essential tools, important tools for upholding patient autonomy in the times that life is extended so much and the patients usually are not in state to make decisions for themselves in the end of life situations. So it's important to think about this. And for this, physician education, public awareness, and systemic support for shared decision making are very important. Thanks for your attention and patience.
Thank you. May I now invite Natasha Lokens, who will speak on consent and voluntary assisted dying. And I do ask you to kindly stick with the 10-minute time so everyone gets a fair go.